Okay, I came into the office this morning, opened up my email, and there was a notice that the U.S. Department of Justice has received a $34 million payment from a company called Infosys, which was the penalty for violating I-9 employment eligibility record-keeping requirements, as well as other allegations of fraud in the hiring of non-U.S. citizen workers. $34 million is the highest amount that's ever been paid in an immigration prosecution. So hopefully this will grab the attention of American employers, and to the point that they'll recognize all employers in the United States have an obligation to participate actually as agents of the Immigration Service in filling out an immigration form called the I-9 Employment Eligibility Verification Form, and keeping a record of each employee they've ever hired, so that if they're ever audited by the U.S. Immigration Service, specifically the Immigration and Customs Enforcement, or ICE, they'll be able to prove that all of their workers are completely authorized to be employed in the United States. It's amazing to me that all the time I run into employers that are totally unaware of this requirement, even though it has been part of the law since 1986. And employers that are found not to have complied with the law, either by not keeping I-9 records or by keeping them but having mistakes in the I-9s, are subject to sometimes very, very large penalties. We've never seen a $34 million penalty before, but in the last few years, ICE has started really ramping up their enforcement efforts. More and more employers are finding themselves under scrutiny by the Immigration and Customs Enforcement Agency, and more of those are ending up paying fines that they could have avoided if they had known of their responsibilities, and in many cases if they just asked for a little bit of help to make sure that they are filling those forms out correctly. So, what do you need to do as an employer to meet your obligation as an agent of the Immigration Service? Well, the first thing is you have to make sure that whenever a new employee is hired, that an I-9 immigration form is filled out. The employee is required to fill out Section 1. It's basically information about who he or she is, where they live, contact information, and what their justification for being employed in the United States is. If they're a U.S. citizen, then they need to demonstrate evidence that they are a U.S. citizen. If they're a foreign national who is here under a employment authorized visa, then they need to provide evidence of that. And they sign an attestation in Section 1 indicating what their legal status is and what sort of documentation they choose to provide to prove that. Section 1, the employees section, has to be filled out within 1 day after that employee begins work for hire. So, and it can't be filled out before the employee has accepted a job offer. So an employer is not allowed to use this I-9 requirement ahead of the offer to be employed. It can't be used as a screening tool, although that certainly seems to make sense to employers who want to avoid hiring unauthorized workers. But the way the scheme is set up, you can't look at the paperwork until after you've extended the offer of employment. Once that offer has been extended and the employee has begun work for pay, you have 1 day to make sure that that employee completes Section 1 of the I-9 form. Once the employee has completed his section, the employer is responsible for Section 2. Section 2 is where the employer looks at the documentation that the employee provides to demonstrate, number one, their identity, and number two, their eligibility for employment. The employee gets to choose which documents they will present. They have to choose from a specific list, and that list is found on page 2 of the I-9 form. But the employer is not allowed to tell the employee which documents that employer wants to see. And believe it or not, companies have been fined thousands of dollars for implementing policies whereby their HR folks tell every employee, we want to see your green card. If you're a U.S. citizen, we want to see your U.S. passport. The employer is not allowed to specify which documents can be provided. The employer can only say, here is my list of documents that comes off the I-9. These are accepted by the government. You're free to choose which ones you want to present. And the reason for that is to avoid discrimination. When this law was passed, again, way back in 1986, there was a lot of concern that it would be used to discriminate against workers who looked a little bit different or might have had an accent or might have sounded just right but actually were born in another country. And so there are a number of rules that prevent or are intended to deter discrimination. And one of those is the employee gets to choose which documents. Okay. Section 2 has to be filled out by the employer. The employer looks at the documents and then in Section 2 of the form records the name of the document, the government agency that issued the document, any identifying numbers, and the expiration date shown on the document. That all goes into Section 2. That has to be completed and signed by the employer by the 3rd day after that employee begins work for hire. So the first day that he's working, that's day 0. The second day is day 1, day 2, day 3. By the end of day 3, Section 2 has to have been completed and signed by the employer. If not, that employer will be subject to fines and penalties if they're ever audited. All right. Many employers are worried that, well, how do I know if the documents are valid or if they are fake? The employer is not required to be an expert in forensic document examination. If the documents look valid on their face, if they're not obviously something that doesn't pertain to this particular person, if they're not obviously fraudulent or run off on a mimeograph machine or a Xerox, something like that, as long as it's not obvious that the documents are invalid, the employer pretty much has to take them at face value. If the employer does have questions, probably would be a good idea to consult with an immigration professional who really can tell the difference. But generally, if the document looks like it's valid, you pretty much need to accept that that is a valid document. Okay. If the document has an expiration date on it, then you need to make note of that and have some sort of a tickler system so that on before the expiration date, the employee can be notified that they will need to present new evidence that they are continuing to be authorized for employment in the U.S. That does not apply if the employee has shown you a permanent resident card or a U.S. passport. Those cards and the passports have expiration dates, but the status that they reflect does not expire. Your U.S. citizenship does not expire if your passport expires. A green card holder, a permanent resident, his permanent resident status won't expire even though his card will. So those do not need to be re-verified. For those that do need to be re-verified, a year, 2 years, 3 years down the road, you get your little reminder in your tickler system, have the employee show you new documents. Again, it's up to the employee. They can show whatever documents they want at that point, just like originally. But the documents that they show you, those get recorded in Section 3 of the I-9 form. And that's basically what the requirements are. It can get much more convoluted and complicated than that. Some of the questions on the form are considered to be technical and procedural. They may have errors, they may not even be completed, but if you can show that you made a copy of the documents that the employee showed you and that that copy was attached to the I-9 form, you may be able to avoid a penalty if the information was not correctly transferred to the form. Other questions on the I-9 are considered substantive, and if you have an error there, it doesn't matter what's attached. You're going to have to pay a penalty for that one. Okay, so how long do you need to keep these I-9 records? Basically, Every I-9 has to be kept for at least 3 years from the date that it was created. In other words, 3 years from the date that that employee was hired. And they also have to be kept for 1 year after an employee is terminated. So if an employee is hired, you know you're going to have that I-9 for at least 3 years. If the employee works for you for more than 2 years, then you also need to be keeping track of whenever he's terminated, you have to hold on to that I-9 for 1 more year. Okay, and you need to keep all the I-9s together. It's generally not recommended that you keep them mixed in with other personnel records. The I-9s should be kept in a separate spot where you can locate them. And it's really important that you are able to present those I-9s on 3 days' notice from the Immigration Service. For smaller companies, that's probably a little bit easier. For large companies that have offices spread out around the state or maybe spread out around the country, if they have a centralized location for all their I-9s, it can be pretty challenging. But the law is, and ICE is pretty rigid about that. Once they give you an audit notice, you've got 3 days to pull all those records together. If you do get audited, you definitely will need to contact experienced legal counsel to help you with that process. Don't go it alone. This is not an area that is as simple as it might seem. It's not as simple as it ought to be, but you really need some guidance and help there. So to wrap up, what should you be doing now to make sure that if that day comes, you'll be prepared? Number one, make sure that you are keeping I-9 records on all your employees. Number two, take stock. Get an independent evaluation, an independent audit of your I-9s. I have never gone through the I-9 records for an employer without finding errors on at least half of the I-9 forms. And every error that you find on a form is a potential fine of $100 or more. So it's usually worthwhile to hire somebody that knows what they're doing to go through your I-9 records and make sure that they are in order. And if they're not in order, that person can help you to mitigate the potential liability that you have there. You cannot throw out a form. If the error is there, it's there. But what you can do is document that you've made efforts to clean up the records, you've made efforts to go through and correct everything, and when it comes time for an audit, that will reflect favorably, showing that at some point in time you became aware of your responsibility and you did the right thing. You went to find out what needs to be done and you put everything right. And finally, it's really important that you create a compliance policy and implement it. A compliance policy for a small employer might be fairly simple, and the basic premise is fairly simple even for a large corporation. You have to make sure that there's a system in place so that every new hire fills out the I-9 form and has the employer part filled out within the 1 day and 3 day time periods after the date of hire. And that they are filled out by people that really know what they're doing, that know what is acceptable and what is not. Because if you get the I-9s done correctly the first time, you'll save yourself a ton of headaches farther on down the road. If you need any further help, please feel free to give us a call. We're here to help you. And this is definitely an area, again, where you don't want to just go it alone.